All right, and I want to thank Phil LaPorte for his patience with our tardiness and the schedule. His eyebrows are going up and down, which is an indicator of nothing good for me down the road. I know if you look at your conference schedule, you'll see that the next session is a mock arbitration, and but it's mock only in the sense of mock chicken. It is a very serious and event, because grievance procedures in the system of justice in the workplace are such an important part of the collective bargaining environment that is part of our lives. And I can't think of anybody better in the nation to help direct a display like this. And so, in fact, I'm going to participate as one of the members. So I'm going to take this off and go and pen, and I will turn it over to Dr. LaPorte.
You want us to put these on?
I think people will be able to hear better.
Well, I've never needed a microphone. Is anyone in the back can't hear my voice? No. All right. I have 7 brothers and sisters. I thought that was impressive until I met my wife. She has 12. So in order to be heard, you had to speak up. So I can. Ladies and gentlemen, we are going to engage in a mock arbitration. I want to bring the participants up to date as to what has transpired. You are looking in at the hearing. We have counsel for both the agency, the employer, which is the United States Department of the Treasury, the Internal Revenue Service. The employees, bargaining unit employees, are represented for the purposes of collective bargaining by the National Treasury Employees Union. The grievant in this case is a revenue agent. He goes and collects taxes, he conducts audits, he does field investigations. Well, as in many federal sector removal cases, this case has been scheduled for 2 days of hearing. In the federal sector, you don't get fired, you don't get terminated, you don't get canned, you get removed. All right? So when you hear the term removed, it means you're fired, you're terminated. Now, yesterday we convened this hearing, and the parties agreed at the outset that the issue was timely and properly before me in arbitration. There were no claims that the grievance was beyond the scope of the national agreement. There was no claim that the grievance was filed untimely. So the arbitrability questions were easily resolved because there were none. Right? The parties stipulated as to the specific issue that was before me in arbitration. And that issue is as follows: was the removal of the grievant for such cause that it will promote the efficiency of the service? If not, what shall be the remedy? Now, this is drawn from Article 38 of the parties' collective bargaining agreement. You see, again, the wording in the federal sector is a little bit different. Most cases, perhaps that you have been involved in, the issue would have been, was the disciplinary action for just cause? If not, what shall be the remedy? Right? So a little bit different language here. And I wanted a little bit different language so you'd pay closer attention to some of the nuances that exist in the federal sector
so that you would not assume that this is, something we've heard before many times, because perhaps you haven't, right? So during that hearing yesterday, the first day of the hearing, the parties submitted a series of joint documents. Joint document number 1 was a copy of the national agreement that has been entered onto the record as evidence. Joint document number 2 was a copy of the grievance contesting the removal action. Joint 3 was the Tigta investigation report. What is a Tigta? Well, that is the security authority that is employed by the Internal Revenue Service to protect revenue agents and other employees of the IRS. They have their own security force on site, right? So that is what Tigta is. So that report was introduced as Joint Exhibit 3. The author was Officer Oliver Simmons. Joint Exhibit number 4 was the proposed removal action, right? In the federal sector, you get a proposed disciplinary action. Then the employee has the right to respond, and the agency has to hold a response hearing. And usually those response hearings are transcribed. So that was another joint document, the transcript of the employee's response to the proposed removal action. Joint number 6 was the final removal notice. Joint 7 was a copy of the Douglas factors. Douglas factors? Well, who is that? Justice Douglas? The Douglas fir? Who's Doug? Senator Douglas? Well, my stars, the Douglas factors are incorporated into the collective bargaining agreement. And so the parties are aware of the existence of those Douglas factors. If you want a shorthand, the Douglas factors are the federal sector equivalent to the 7 tests of just cause, right? Was there notice? Was the rule appropriate? Was the employee given sufficient notice? Did the deciding official take into consideration any mitigating factors in determining the appropriate level of disciplinary action? Did he take into consideration any aggravating factors? This is outrageous. It brought upon the agency adverse publicity. Was there a mitigating factor? Well, this situation came in close proximity to the time where there was an assault on Internal Revenue Service revenue agents, and every revenue agent was at a heightened sense of sensitivity to perceived threat. Perhaps that might have been a mitigating circumstance. So the Douglas factors, okay, incorporated into the agreement. And the parties, of course, had access to the personnel file of the grievant, Mr. Jerome Jackson. And the parties, of course, have memorized all these joint documents, and they provided them to me in this wonderful stack here, but they forgot them all, so they don't have them today. But they're already on the record, okay? Now, here we have this case where we had Mr. Jackson, who was involved in an altercation. The situation is that Mr. Jackson here is a revenue agent. Mr. Jackson over here. And he got into an altercation. Yesterday we heard testimony from a number of witnesses. We heard from a customer service representative, Ms. Rose Constance, talked about what she heard, what she observed, her conversation with a Mr. Charles Allen. Mr. Allen also testified about his experience with Mr. Jackson conducting an audit and a site visit at his business. And Mr. Charles Allen testified about how he went to the IRS facility in Nashville seeking to speak to the regional director. His efforts were thwarted. There was ultimately a confrontation with Mr. Jackson that had resulted in a physical altercation. So we've heard from Mr. Allen, we've heard from Ms. Constance, we've heard from Officer Simmons, and the agency, represented by counsel, Ms. Joan Hill, has one more witness they wish to call, and that is the deciding official in this case, the regional director of the Internal Revenue Service. And he'll testify on direct examination after I swear him in, and he'll be subject to cross-examination by distinguished counsel for the union, Mr. Jed Marcus. Once we have heard testimony from the regional director, Mr. Randolph Winston III, we will hear from the griever. That is the only witness that the union is going to call. We'll hear the grievance side on direct. He'll be subject to cross-examination by counsel for the agency. And at that point, ladies and gentlemen, the union will rest its case, and they will establish a schedule for filing post-hearing briefs. So I think I've caught you up to date. We are ready to go back on the record. Good morning to everyone. Today is November 16th, 2012. This is an arbitration hearing before Arbitrator Philip A. LaPorte. The parties have convened this hearing at the Arnold Air Force Base in Tullahoma, Tennessee. The record reflects that a full day of hearing was held yesterday. The agency continues to present its case in Maine. Ms. Hill, you've advised me that the agency has one additional witness to call. Is that correct?
Yes, sir.
Thank you, ma'am.
And I believe we swore all the witnesses in at the beginning of the hearing. Is that correct, sir?
No, it's not.
Okay.
Mr. Marcus, I understand from your witness list that you have one witness that you plan to call. Is that correct?
That's correct, Mr. Joan.
All right, thank you very much. All right, very well. Ms. Hill, could you please call your next witness?
Yes, at this time we call Randolph Winston III.
All right, very well. Good morning, Mr. Winston. Please state your name for the record.
Randolph Winston III.
All right, very well. Mr. Winston, would you kindly raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth to the best of your knowledge and recollection?
I do so affirm.
Very well. All right, very well. Ms. Hill, the witness is with you.
Is this on or no?
You're supposed to put in batteries. Yeah, here it is.
No batteries. I'll try to project as well.
This is a good one.
Good morning, Mr. Winston.
Good morning.
Please state your name again for the record.
My name is Randolph Winston III.
And do you go by Randolph Winston or is...
Call me Randy.
Thank you. By whom are you employed, Mr. Winston?
I'm employed by the United States Department of the Treasury, Internal Revenue Service.
And what is your current job title?
IRS Regional Director for the Nashville, Tennessee region.
And what area does the Nashville Regional Office cover?
We cover Middle Tennessee, East Tennessee, going south to Chattanooga and into southern Kentucky up north.
And what are your job duties as the IRS Regional Director?
I have the overall responsibility for the operations of the IRS office in Nashville, providing revenue collection services for the Department of the Treasury, services and advice to businesses and individual taxpayers in the Nashville region. I'm responsible for approximately 200 employees in the Nashville region, and program directors and management personnel ultimately report to me. I have the final authority in making decisions on disciplinary actions and adverse actions up to and including removals.
How long have you served in this capacity?
10 years,
How long have you been employed by the IRS?
30 years.
So what other positions have you held?
Well, I began my career with the service in 1982 as a customer service representative. I was promoted to tax analyst, then revenue agent, subsequently supervisory manager, program director for small business, and then to assistant regional manager before being promoted to my current position in 2002, 10 years ago.
Are you responsible for the administration and enforcement of work rules and policies?
Yes,
Does the agency have a policy prohibiting workplace violence?
yes.
What is that policy?
The agency has a zero tolerance policy regarding workplace violence.
Are IRS employees permitted to punch taxpayers?
No, they are not permitted to punch taxpayers at all.
And what would be the penalty for committing workplace violence?
Removal is a violation of a well-established agency policy. Every employee is made aware that any form of violence in the workplace at the IRS will result in their employment being terminated and then being removed from the federal service.
And do you consider punching a taxpayer a form of violence?
Yes.
Do you know the grievant, Mr. Jerome Jackson?
Yes, I do.
How do you know Mr. Jackson?
Mr. Jackson was employed by the agency as a revenue agent in the Nashville IRS regional office. I've known Mr. Jackson from the time he began his career with the agency in 1985 until the time he was removed from the federal service earlier this year.
How many years has Mr. Jackson been employed by the agency?
In some 27 years,
And what kind of employee was Mr. Jackson?
Mr. Jackson was a good employee. He consistently received positive performance reviews. He took continuing education classes to remain current with the tax code and to improve his professional skills. He was helpful to his fellow employees.
Did you want to remove Mr. Jackson from his employment?
No, not at all, but I had no choice. The evidence produced through the investigation, Mr. Jackson's own admission that he engaged in workplace violence by punching a taxpayer in the face led me no choice other than to remove him from federal service.
How did you reach that conclusion?
I read the statements from Ms. Constance, Mr. Allen, and Mr. Jackson, and I read the report submitted by IRS Security Officer Simmons. I read the transcript of Mr. Jackson's response hearing that was held on July 17, 2012. I reviewed the agency's zero tolerance policy on workplace violence, and I considered the Douglas factors outlined in Article 39 of the National Agreement. I took into account Mr. Jackson's long and distinguished career with the agency and the fact that he had a prior incident with Mr. Allen. After considering all the evidence, the applicable policy, the Douglas factors, I concluded that removal was the only appropriate penalty to impose on an employee punching a taxpayer in the face in the IRS Taxpayer Assistant Office.
Did you consider Mr. Jackson's account of what happened that day?
Yes, I considered his account. However, Mr. Jackson was not required to confront Mr. Allen in the Taxpayer Assistant's office. He could remain in his secure office. He could have called the Tigta security officer. He could have retreated back behind the secure door when he realized Mr. Allen was acting in a hostile and threatening manner. He did none of these things and did engage in the violent act of punching a taxpayer. I have no doubt that removal was the correct action in this case.
No further questions. Your witness?
Thank you very much. So my name is Judge Marcus, and I represent the plaintiff in this matter. Just asking a few questions. First of all, you would agree that during Mr. Jackson's
Is it
I'll
on?
repeat, there is no script for my cross-examination. Oh.
And we said you gotta wing this one.
Just follow my lips, I'll tell you where you are. Okay.
Objection leading.
Could I have a drink?
All right, very well. There's an objection that the question before the witness is leading. Overruled, counsel. The witness is on cross-examination. Mr. Marcus is allowed to ask leading questions on cross-examination. Please proceed, counsel.
Mr. Jackson was an exemplary employee during his 27 years, wasn't
Yes.
he? Not a single blemish on his record.
Nothing of substance, yes.
No disciplinary record.
No disciplinary.
Outstanding credentials.
Yes.
Did a good job with taxpayers and, always did
Correct.
good. Continuing education, constantly keeping himself updated on tax law and the tax code.
As we require in all agents.
And very good on assisting other employees.
Yes, it was.
Okay, now, with respect to the conclusions that you reached, you indicated that the workplace violence rule left you no choice but to seek removal of Mr. Jackson. Is that correct?
Yes.
But in fact, the contract gives you a choice, doesn't it?
So,
Do you want to provide him with a copy of the contract, counsel?
If counsel would be with show where the witness goes one, please.
Is there a particular section?
No, just show him the contract and I'll get him over it. Now, in fact, you're entitled, as the regional director, the contract requires you to take into consideration a number of factors to decide whether or not removal or any other form of discipline is required. Isn't that correct?
I took into account factors that pertain to this case.
And you testified that you considered his long and distinguished record, correct?
Correct.
You testified that you took into account some prior incident that you didn't fully testify to, but that's okay. We're not really going to focus on what is obviously an error in the script.
The Writers Guild will be watching. Go ahead, counsel.
Okay.
There's an old adage, it's rule number 1, never piss off the arbitrator. Go ahead, counsel.
Now, you would agree he's a highly efficient employee, correct?
He's competent.
Now, with respect to some of the issues, were there any other factors that you considered in making your decision?
Those that I testified to.
Okay, so no others?
No others.
Okay, so you didn't take into account the provocation from the taxpayer, did you?
We took testimony on the circumstances.
Well, you took, but I'm asking you whether you considered the fact that Mr. Allen provoked. Didn't he come at my client with fists of fury?
Well, as I testified earlier, we have policies, procedures and protocols for dealing with individuals who may be disruptive, and the agreement chose not to follow the well-established procedures that would have both protected himself and inhibited this event escalating to the state that it did.
Well, you didn't testify to any rule that said that a tax agent or any IRS employee couldn't go out into the lobby, did you?
Of course, people can't go into.
Okay, so he didn't break any rules by going out into the lobby, did he?
He did not follow the guidelines for dealing with.
Well, what guidelines did you testify to that said that a tax agent can't go out into the lobby to try to calm a taxpayer down? Isn't that part of the customer service
In his
experience?
continuing education classes, he was instructed and he understood that when you have had complications with individuals in the past to display this kind of potential behavior, that security should be aware and that you should not put yourself into a position where this kind of confrontation
that Mr. Jackson was technically skilled?
In what way?
Well, how about his job?
In the performance of his review of cases and data. Yeah.
Okay. And given the fact that this is an unusual circumstance, correct? You would agree with that, that this is,
It is
isn't this
unusual.
record extremely unusual?
It's unusual in the service, yes.
And that it has, other than, obviously, as an issue of the Workplace Violence Act, but other than that, it doesn't have any specific bearing on his ability. This you call misconduct, I'll go with your word, this alleged misconduct, doesn't have any particular bearing on his ability to perform his job, correct?
Well, this case, this incident itself, so grievously steps over a very crucial boundary in the performance of his duties. This is one reason that we have a security service.
So you would have preferred that Mr. Jackson have his face punched? That would have been better. You would have preferred to sacrifice his face so that you can maintain this so-called zero tolerance policy, because there's no testimony disputing the fact that Mr. Allen was coming at this guy.
Objection.
Ms. Hill?
I think it's a mischaracterization of what the testimony was, that to the extent that the grievant actually entered into an area where Mr. Allen was, and it's not necessarily assumed then that Mr. Allen was coming towards the grievant.
I don't think there's been any dispute in any of the testimony given yesterday that whether or not, you know, Mr. Allen subjectively was actually going to hit him certainly was evident from an objective viewpoint that any person standing there would have felt he was going to be hit, that he came at him, used abusive language.
All right, counsel, I believe you're now testifying. The grievant is on the witness list. The objection is sustained. Move on, please.
Okay. Given the fact that he's a highly skilled employee, given the fact that he has an otherwise unblemished record, given the fact that this particular engagement doesn't have a specific bearing on his ability to do the job, there were, in fact, the potential for his rehabilitation is rather high, isn't it?
That would not be an area that I would be confident to.
But isn't that one of the Douglas factors that you said you considered? One of the Douglas factors is the potential for the employee's rehabilitation. You were supposed to specifically consider that. Obviously, you haven't.
The way you phrased the question
Okay.
was different than the Douglas factor.
Okay, so let me rephrase it again. You agree, don't you, that he has a high potential for rehabilitation, don't you?
I considered that.
You did. And what was the, and how did you come out on it?
That is one of a number of considerations, and it does not trump all of the other considerations that apply in this matter. The zero workplace tolerance policy is one that is there for a very important reason, and there are many individuals in life who are competent in the performance of their jobs, but then act in a way that so grievously violates the central rules of the workplace or civil society that we cannot discount them.
Now, you could suspend him. You could have suspended him.
The nature of this incident.
I'm just saying, that was one option available to you, correct?
I believe that would be an option.
You could have required him to go to anger management training, correct? That's an option that was available to you, correct? You could have fined him. That was an option available to you, wasn't it?
I have to look.
All right, just let me take judicial notice. There's no provision in the contract for fining an employee. Demoting them, yes, but not fining them. All right, so I have that, counsel.
Well, when I said fine, I meant the motion.
Let's see if we can move on and wrap this up, Counsel.
Okay, well, I think I'm done.
All right, very well. Anything briefly on redirect, Ms. Hill?
Just a couple of clarifications. You mentioned his continuing education. There is actually a program that teaches the agents about de-escalation protocol. Is that correct?
Yeah, there is. The fact that we have our own security service is itself objective confirmation of the fact that we expect that there may be tense situations and possible confrontations in the practice of our service. And also that we have secure rooms where our agents can interact with individuals. It's again recognition that we're well aware of the possibility of these kinds of confrontations. And then finally, in our training and continuing education, individuals, including grievant, receive specific training on how to both anticipate and evaluate and then act to avoid exactly this kind of circumstance developing as it did.
And this training came about as a result of the rise of the Tea Party movement. Isn't that correct?
Objection, Your Honor.
All right, sustained. You want to rephrase?
At what time was this de-escalation training implemented?
Within the last 2 years.
And was there a specific concern of the IRS to require this training?
Objection, relevancy is going beyond the scope of cross-examination.
All right, very well. There was an inquiry, a question, and the witness did respond with continuing education. So he did testify on the point of training. Therefore, I'll allow the question. The objection is overruled.
The service has had continuing education classes addressing the potential of recognition of, the potential of, and how to best address in practice the possibility of confrontations of violence in the workplace. And so that is a long-standing policy. Events in recent years recognizing coordinated, organized groups that have specifically addressed the IRS and its role in government service have led to an intensification of focus on these issues in continuing education.
And does the IRS believe that these type of organized protests will continue?
Objection, Your Honor.
Sustained. Calls for speculation. All right, I think I've heard enough from this witness. All right, very well. Thank you.
I have no questions on recourse.
All right, very well. Thank you very much, Mr. Marcus. All right, time out. Now, one of the reasons I did not script cross-examination is I wanted each attorney to have some leeway, and I wanted the witness not to know what the question was going to be, because that is the way it actually happens. And I wanted whomever was going to serve as the witness here to feel that. And reading Dr. Canak's body language, I'd say he felt it, right? So, you had a demonstration of what an effective cross-examination is like. All right? Boring in questions, suggestions, perhaps confusing the witness somewhat, but you never know. All right? But he did recover. He talked about policy, talked about training, and then on redirect, Ms. Hill tried to repair some of the damage that was done on cross-examination. All right? So, I think we got that example across, and they say the best teacher of all is experience. So with that, we're back. And I understand, Ms. Hill, that the agency now rests?
Yes, subject to recall on rebuttal if necessary.
Very well, thank you. Mr. Marcus, I understand that you have one witness to call. Would you please call your first and only witness?
Mr. Joan Jackson.
Good morning, Mr. Jackson.
No, you keep it up.
We'll take that one.
Mr. Jackson, would you kindly raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, to the best of your knowledge and recollection?
To the best of my knowledge, yes.
Yes, sir. All right, very well. The witness is with you, Mr. Marcus.
Good morning, Mr. Jackson.
Good morning.
Speak a little louder.
Good morning.
Please state your name for the record.
Jerome Jackson, and most people know me as JJ.
Where were you employed?
I was employed by the Internal Revenue Service at the Nashville Regional Office.
And how long were you employed by the IRS?
Since 1985, that would make it 27 years.
What positions have you held with the IRS?
I began my career in the federal service as a customer service representative, answering questions from individual taxpayers. I went through a training program on the tax code and effective customer service after being hired by the IRS in 1985. I later was promoted to a collections representative position, a tax analyst position, and eventually to a revenue agent position at a GS-12 annual salary.
Would you please describe for Mr. Arbitrator what your educational background is?
I earned a BA degree in accounting from the University of Tennessee in Knoxville. I have enrolled in annual IRS continuing education programs for each year of my 27-year career with the IRS.
What are your job duties?
I review tax cases from individual tax returns, Schedule C tax returns for small business and sole proprietorships, Schedule S cases for incorporated and larger businesses, and for returns that have been filed for other businesses. Cases are processed through an initial review process with the payment information cross-reference using a payroll and payment information that is filed by businesses, governments, and nonprofit institutions with the IRS and other government organizations. Some returns are flagged due to unsubstantiated information or claim deductions that are extraordinary or without documentation. These returns become cases that are referred to the revenue agents for further investigation and possible further action. My duties are generally to review tax returns that have been flagged, investigate the facts for such cases, and determine if applicable provisions of the tax code have been applied properly.
Can you provide an example of a tax return with an extraordinary deduction claim?
An individual taxpayer who claims to be a member of the clergy and that his private residence is a church. A taxpayer claiming that his suburban home is actually a honey farm. A small business claiming that his wife and 2 children are employees of the business and that their wages are business expenses when they perform no work for the business. I could go on, but I think you get the picture.
I do, thank you. Are you familiar with a taxpayer by the name of Charles Allen?
Yes, I am.
And how do you know Mr. Allen?
Mr. Allen is a taxpayer whose tax return was flagged for various irregularities, including claiming that his wife and children were employees of his business and claiming 100% depreciation of equipment for 5 consecutive years. His case was assigned to me and I conducted a field visit to Mr. Allen's business.
What did you find?
I made an appointment to visit the Allen exterminators and arrived at his business office at 9 a.m. in the morning of June 5th, 2012. The office had a life-size poster of Wesley Snipes with a caption reading that the IRS was a bunch of outlaw thieves who need to be stopped. He also had a Tea Party Patriots poster that called for the destruction of the Internal Revenue Service. I noticed that there was only one desk behind the office. He claimed 4 administrative employees, including 2 billing clerks and an administrative assistant. These positions were allegedly filed by his wife and 2 children. Further review found a claimed business deduction for a billing service that sent out all the invoices for the business.
Find any other irregularities?
Yes. Mr. Allen claimed a home office at his personal residence as a business expense when his business had a fully furnished office. He claimed expenses for a lawn service when the business did not have a loan. There were numerous other claims for business expenses when there was no such equipment to be found at the business location.
What was the result of your investigation and audit?
My findings were to disallow numerous deductions, resulting in Mr. Allen having a tax liability of approximately $100,000 in back taxes owed to the U.S. Treasury.
What was his response?
He was not pleased. He called me at my office and told me that he was going to take this up with my boss and that he would fight the imperial federal government.
When did you next see him?
Next time I saw him was at the tax assistance office at the federal building in Nashville on June 26th.
Did you know that Mr. Allen would be coming?
I had no idea he would be at my office that day.
Did you have a confrontation with him?
Yes, I did.
Please tell us what happened.
I was in my office working on a case when I heard Rose Constance speaking to someone on the telephone, and I heard shouting coming from the Taxpayer Assistance Office. I asked Ms. Constance what was going on. She told me that there was a man in the Taxpayer Assistance Office calling her a, quote, blood-sucking bureaucrat. I asked her if she knew who the man was, and she answered it was Charles Allen. I recognized the name and went out of the Taxpayer Assistance Office out to the Taxpayer Assistance Office seating area to speak to Mr. Allen. Allen continued to shout into the phone, demanding to see Mr. Winston. I approached Mr. Allen and asked him to please calm down and stop shouting. He was surprised to see me. He hung up the phone and told me he did not want to speak to me and that he had come to see my boss. He said that I was a worthless parasite and a threat to freedom and liberty. Allen then crossed the room and approached me with his hands raised and his hands balled up into a fist. He continued screaming at me and called me an ignorant, irresponsible jackass. I felt threatened by him charging at me with raised fists. I just reacted and punched him in the face before he could attack me. Allen got a bloody nose and began yelling that I had assaulted him. The next thing I knew, the Tigta officers came in and took statements from both of us.
Did you feel physically threatened?
Yes.
Why?
This man had posters in his business calling for the destruction of the IRS. He came at me screaming that I was an asshole with his fist raised in a rage. All I did was protect myself from a raging maniac. Protecting and defending myself against a raged taxpayer should not result in me losing my job.
Have you been a good employee, sir?
Yes, I have 27 years of productive service with the federal government. I have not had any prior disciplinary action at all in my entire career. I went out to the Taxpayer Assistance Office on June 26th to try to calm down an angry taxpayer that was harassing a female IRS employee. Charles Allen is the villain in this story, and he's the one who should be punished and not me.
Do you want to return to the service as a revenue agent?
Yes.
Do you think that removing you from federal service serves to improve the efficiency of the agency?
Absolutely not. I've been a major contributor to the agency for all my 27 years. I want my job back, and I want my career back.
No more questions.
All right, Ms. Hill, the witness is now available for cross-examination. If you need a moment or two, ma'am, you may have it.
We're prepared to go forward.
All right, please proceed.
Mr. Jackson, one of your responsibilities as a revenue agent includes regular contact with the public, correct?
Correct.
You actually have to go to the business sites or the individual's residence and do what we call field audits, correct?
Correct.
And that sometimes takes you to rural areas such as East Tennessee where Mr. Allen lived, correct?
Correct.
Now, you work for the taxpayers, don't you?
Absolutely.
And Mr. Allen is a taxpayer.
Yes, ma'am.
He pays your salary.
Yes, ma'am.
What line of business did Mr. Allen have?
The starting business.
An exterminator?
Mm-hmm.
And as part of this encounter with him in the Taxpayer Assistance Office, you actually had to go through a locked door to enter the customer service area where Mr. Allen was, correct?
Yes, ma'am.
And there's glass that is across the area so that there's actually no way for somebody to actually come into this area unless the door is unlocked. I mean, there's no counter that they can barrel over. You know who the Tea Party Patriots are, right?
Yes, ma'am.
And you knew that part of this de-escalation training that was provided to the agents was in direct response to the Tea Party movement.
Objection, Your Honor, calls for facts, not in evidence.
All right, very well. Ms. Hill, you have some foundation regarding this assertion that the witness was aware that the training was based on threats posed by the Tea Party Patriots and their confederales?
Well, I think the regional director has testified as to this training and the de-escalation training, that workplace violence had been part of the training for a number of years, but this specific part of de-escalation was implemented as part of that training as a result of the Tea Party protests.
But the question was what he knows and was aware of, not what the policy understanding was when the IRS implemented.
All right, very well. The question is to the witness as to his knowledge. Do you have any foundation to establish that this witness participated in such training?
He did admit that he did attend these de-escalation training as part of his continuing education program within the IRS, mandated of all agents and other employees.
He testified, as I understood it, that he participated every year in continuing education. I do not believe the record will show that he testified regarding specific training. You want to pick it up there, Counsel?
Yes, but we've also provided the union with his personnel record that has all of the sign-in sheets for the various training programs that they attend, and I believe one of the documents in that personnel record does reflect the training and the sign-off that Mr.
I don't believe,
Jackson.
although I don't believe that's the case. If arbitrator wishes it so, it's fine with me.
It's a joint exhibit, you can refer to it.
It is, and of course I spent the entire evening last night reviewing all of those exhibits, and I do note that there was a signature acknowledge his participation in said continuing education class. With that judicial observation, you may proceed.
Yes. And part of this education program, they gave specific examples about the protests of the Tea Party as they were being announced.
A lot of examples were given about lots of things.
Okay.
But whether it applied just to this particular case, I don't know.
You knew Mr. Allen was a member of the Tea Party Patriots.
I gathered it with the things he had in his office that he was at least a supporter of some sort.
Okay, and one of the principles, as reflected in this Wesley Snipes poster he had hanging in his office, said that they called for the destruction of the IRS. Now, when he was in this customer service area, after you entered through the locked door, what kind of names did he call you?
My recollection was jackass and asshole, and that seemed like adequate enough to give me some pause.
He called you a worthless parasite, didn't
I believe so.
he? And he's in the extermination business?
Well, makes you kind of wonder a little bit about what they might do.
Now, as part of this $100,000 back tax determination, there's also a criminal investigation of Mr. Allen.
I'm sorry, has there been any testimony regarding that, Your Honor? Does that question include facts and evidence?
I believe it's in the background
Yes,
materials.
yes,
from
that
analyst
is, all right.
testified.
Do you have an objection, Mr.
Yeah.
Marcus? Yes.
Nobody's testified to that.
All right, very well. There is a background report that is admitted that does specify that the actions by Mr. Allen are being considered for possible criminal activity. Counsel, where are you going with this? the grievant was fired for violation of the workplace violence policy. Can you link up these facts you were questioning him about that he didn't testify to during direct, and how does it relate to the grounds for his dismissal?
Well, I think it shows the grievant knew of Mr. Allen's history, his relationship, the support of the Tea Party Patriots, as well as the potential for criminal prosecution. Again, going towards the issue of government overstepping its bounds, and again, that's one of the core principles of the Tea Party Patriots, to the extent that Mr. Jackson knows of his involvement with the Tea Party.
Mr. Arbitrator, if the point of this government is that most taxpayers hate the IRS, we'd stipulate to that, and I suppose the conclusion would be that no IRS agent should ever have any dealings or exchanges with any taxpayer.
All right, let's see if we can get through this. I think it's stipulated, and we do have evidence that Mr. Jackson was aware of Mr. Allen's support of the Tea Party Patriots and their agenda. All right, so that's on the record. Can we move on, Counsel?
Mr. Jackson, you stated in your testimony that you felt that Mr. Allen should be punished. What action can the IRS take against him other than what they have already done with their investigation, the audit, the criminal investigation that's ongoing?
Objection, Your Honor. It's beyond his kin to describe what, if any, power should be brought by the government against this guy on a criminal basis. He's an IRS agent. He's not conversant with the criminal code. It's not his job to know these things. And there's been no foundation laid that he's in a position to answer that question.
Ms. Hill?
He's offered in his direct testimony that he felt that Mr. Allen should be the one punished.
All right.
I'm just
All right,
inquiring as to the
all right,
nature of
thank
that
you,
punishment.
thank you. I don't find it instructive as to whether or not cause exists for the disciplinary action based on whether or not this witness feels Mr. Allen should be punished in a particular way. So I'd ask if you could please inquire in another area.
Is workplace violence acceptable at the IRS?
No, ma'am.
Is it acceptable in any government agency?
Objection, Your Honor. Beyond the scope. He doesn't know what other agencies find acceptable.
All right, sustained. He's answered the question about what he knows in the IRS. I have it.
And if Mr. Allen would come back in the office, you would probably respond in the exact same way that you did on that day on June 26th.
I felt threatened at the time. On reflection, I would not do it again because I wanted to try to help diffuse the situation because I felt there was a concern for my coworker, and I felt like we needed to try to diffuse it, to try to move on about our business, of interacting with the taxpayer.
And you didn't consider calling the taxpayer security service that they're in the building?
I felt like there was, time of essence, and I felt that I had some relationship with the gentleman, and I thought maybe I could refuse it.
So when asked that whether you would hit him again, your answer was yes.
No. I'm not going to stipulate that I would ever hit a taxpayer again because, it's just, I was threatened at the time, but I'll do my best in the future to make sure I don't put myself in that position.
But your responsibility as an agent is to be interactive with the public and respond to questions that come into the customer service center that are directed towards you, correct? You meet with the customers?
I do have to meet with customers, but I will follow the protocol and stay behind the glass.
Hindsight. Thank you. No further
All right,
questions.
very well.
Just one or two more questions.
All right, please proceed. On redirect.
Just very quickly, when you visited Mr. Allen at his office, he didn't threaten you in any way, did he? I'm sorry?
No, I just felt threatened by all.
No, I'm just talking about at the office.
You know, at the IRS office.
No.
At his personal office.
Right. He didn't threaten you in any way, did he? At that time, he never came at you in what you felt was a physically harming way, did he?
No.
So when you first saw him out in the lobby, you had no particular reason to believe that he came to do you physical harm when you opened the door to go out to the lobby.
He was just being very expressive, and I was hoping to use that.
And is there any rule that says that you can deal with taxpayers who like the government as opposed to those taxpayers who don't?
Not to my knowledge.
No.
All right, very well. The leading question by Mr. Marcus on redirect somehow slipped through there, but all right.
You know the rule, Mr.
I
Arbitrator.
was more, Your
Don't
Honor,
ask
I was
any
more
leading questions
considering
on
whether or
direct
not
unless,
the,
don't ask leading questions on direct unless you can get away with it.
Yes.
I was more considering whether or not the further recross was necessary to the extent that he's characterized Mr. Allen's comments as expressive, when in fact I think he had previously said that he was shouting to the extent that he could hear him from 20 feet away.
Very well. And that question was posed on recross. All right, time is getting away on us here. First of all, I want you to take a good look at these two attorneys, how skilled they are, how quickly they got to those questions, and how comfortable these witnesses got into their roles. And I want you to join me in thanking them for volunteering to participate. Now, we have a few minutes, I believe, Mr. President-elect. Wait till you get Secret Service protection. It'll be impossible. So questions that you have, observations that you have, and then I'll tell you what happened in this case after that. Go ahead. Yes, sir.
My observation is, if this is a continual improvement program on how to deal with the public, why was security not there at a appropriate amount of time? Why did he have to respond? Why wasn't security there? As soon as he entered the building, started shouting on that phone, I think the timeline would be important. I mean, if it's a constant program and y'all are a continual improvement program for security, why was that not in place?
Well, to answer your question, security is there, but they're not on every floor in every IRS facility when every taxpayer comes through. Keep in mind that Mr. Jackson knew it was Mr. Allen in that waiting room before he left and went out into that unsecure area, right? Because he asked Ms. Constance what's going on, and she stated who it was, right? So they could have called, but security doesn't patrol. They have their office and respond to calls. So they're not everywhere all the time, to answer your question. Okay? Yes, sir.
Okay, my question would come up. He testified that it's been within 2 years that he received the class, and if that was the case, I would have been to the point of the other female IRS employee evidently had forgot what was in the class also, because she didn't call security, and he didn't either. So I would have went to the fact that neither one of those had a refresher course within 2 years, and why neither one of those called security. So evidently the class was not too good that the employees, neither one called security. So I would put back the fault to them that they didn't do a good job of training.
Okay. All right.
That's argument.
Other observations? Yes, sir.
I've seen a couple of arbitration cases, and knowing that when the company has a no tolerance rule, generally that holds, no matter what you cross-examine on.
My question is, if security had showed up first and security struck the customer, how would that have been handled?
Well, that'll be next year's case. All right, the sworn law enforcement official does have the authority to use force necessary to control the situation, so it would depend on what the specific circumstances were. But rest assured, there is a rule that you can't punch the taxpayers.
It seems to me there's a, if you will, a critical moment here that doesn't get articulated, and I wonder if in the real arbitration it did. I don't mean to be disrespectful, obviously, but I would think a selling point on the defensive side would be, think about the situation in which I was involved. Right at that very moment, this guy is coming at me with his fist, ready to deck me, and my response is to protect myself. And that's what I think would be very important
One thing
to try and emphasize.
One thing that, and Joan sort of hinted at it, that you didn't get to see in the way we put this together, was that many of the what we as advocates do is draw out the facts. Yeah, we argue a little bit. We try to argue our case a little bit through our questions. But what really happens is we take all the facts, the good and the bad, and we put them together in a story. And at the end, we argue to the arbitrator in a closing statement. So, for example, that was a very prescient point, which, yeah, I could have made a snide remark. I probably should have. I hadn't thought of it, so I'm not. But these
By
are
the time
types
you
of
do the
comments that
brief,
would be
you
made in
would've-
closing, saying, these are the facts, A, B, C, D, and E, from which you should include, Mr. Arbitrator, that the policy was ineffective, the training wasn't proper, he was only defending himself, they haven't followed the Douglas factors, and here's why. So that's why you may not see these things get pulled together.
Thank you.
Just one further kind of comment about he should have retreated argument, which is, I think, the basis or the theory of the government is he didn't retreat, et cetera, et cetera. And again, what we do, laying out the facts, and then that becomes our argument, that's our theory of our case, so we have to essentially convince this arbitrator to adopt our theory, and we use withdrawing inferences, drawing conclusions, and those conclusions have to be based upon facts. And so I think that would have been part of my closing argument or brief to the arbitrator. And these different points as to, what they should have done or what they could have done and what he should have done to the extent of the provocation and duty to retreat.
Just for what it's worth, you asked about the Douglas, you mentioned who Douglas was. I actually worked on the Douglas opinion. I helped to draft it back in the day. It comes from the
1981.
Yeah, it comes from, that's right.
That's right.
I still have the yellow notes from my portion of the case. But it was a committee effort written by probably 20 people before it was done, because I became a judge before they ever issued the opinion. But it was an opinion of the Merit System Protection Board,
Yep.
and that's how it gets into the IRS contract. And for what it's worth, and when I was working on the framework for those factors, they actually came from El Khoury and El Khoury, a number of them at the beginning, and then the board actually then adapted those to incorporate those special considerations that they thought would be appropriate in the federal workplace. And Douglas was a wage grade employee of the Veterans Administration.
Yeah.
Okay. All right. Well, time. Yes. Go ahead. Sure.
Since this was a federal building, what does the video show?
I can't hear him. What do you say?
He asked about the video. Actually, we've just implemented surveillance of these customer service areas now due specifically to this situation, that we have video and audio available to, you know, recognize that when there is somebody flailing, like Mr. Jackson was going.
According to the Freedom of Information Act, if he was a IRS agent, was he armed?
No, there was no video, there was no weapons involved. All right, now, wrapping things up here, I came across this case when there was a grievance that was filed regarding this employee's annual performance review. The grievance was held in abeyance until another arbitrator decided whether or not there was cause for the removal. Arbitrator Stephen Hayford ruled that the employee had engaged in misconduct, that he had punched a taxpayer. However, he mitigated the penalty from a removal to a 15-day suspension. So he was returned to work, 15-day suspension. Then, on his annual performance review concerning customer service, his rating was failed. The prior year evaluation, his rating was exceeds. The policy requires that if you're going to diminish someone's rating, that you must counsel them prior to diminishing the rating. No counseling done. Testimony is, why did you rank him as fails? Because he punched out a taxpayer. Well, the contract says that you have to examine a representative sample of the employee's job performance throughout the rating period. Well, they said we only looked at that one incident, but it was so egregious. Well, the contract says a representative sample. One isolated incident, as they described it, did not constitute a representative sample. Therefore, I canceled the rating of failed and credited him with meets. I couldn't rate him as exceeds when on the record he had a 15-day suspension for punching out a taxpayer. So that's how that case came down. Right? So what we wanted to do is give you a case that had some interesting facts to let you see how the procedure played out, and hopefully through participating and experiencing a hearing, you take away some of the examples and you're able to apply them in your work in resolving disputes. So, yes, of course,
just
sure.
a couple of points, and I'm always taking advantage of opportunities when there's an arbitrator in the room to ask them questions, because I do arbitrations as an advocate, and Jed as well, I'm sure. 2 quick points. Zero tolerance policy. The brother back here said that, you know, they're not looked upon favorably, although I've read some things that, or that they all, excuse me, you said zero tolerance is what it is, arbitrators take it. I've read surveys and discussions by arbitrators who really don't like that zero tolerance, because it does limit and essentially give the employer no choice when we have all of these things like just cause and 7 tests and Douglas factors. Your comment about that, and then also to address the counseling requirement that would have now been part of this factor for performance review, and arbitrators taking the opportunity in a reinstatement such as this subject to 15-day suspension, to also put other types of conditions upon the reinstatement, such as anger management or something like that.
Yeah, well, I mean, the lawyer's favorite term. It depends, right? Some contracts, the AT&T contract with CWA, the only authority of the arbitrator is to find whether or not just cause exists. The remedy is spelled out in the contract, so you don't have that authority under that contract to fashion such a remedy. In other situations, arbitrators have been very creative. However, if their creativity escapes outside of the four corners of the contract, they may subject themselves to having their award challenged in that the arbitrator may be seen to have exceeding his authority. On the question of zero tolerance. Zero tolerance in some instances means no judgment. If you have zero tolerance, how are you going to apply those Douglas factors? If you find this happened and this result, then do you throw the rest of that out the door? I don't think so. All right, so you have to be, careful. And I know that, both Bob and I have had a case involving the unilateral implementation of a policy that changed the term and condition of employment. And whether or not that is allowed, the answer is no. It requires negotiation. So I would have a jaundiced view of zero tolerance policies, right? Now, Jed, we'll give you a chance to make a comment, or you're fine? Good.
I mean, I agree with you on the zero tolerance. I think that, one, it can't be unilaterally implemented because the contract takes precedence unless the policy is negotiated. And moreover, I think zero tolerance policies, whether they, regardless of the issue, is sort of, it just takes all thinking and common sense out of the hands of the people who are required to work under it and administer it. These are generally ridiculous policies. It's just my personal opinion.
All right, one last kicker. The National Treasury employees in the IRS have a permanent panel of arbitrators, right? And the arbitrators can be renewed or they can be fired. After Arbitrator Hayford issued this award, putting him back to work, the agency fired him. Okay, so, with the arbitration business, you're going to have some parties that are going to be unhappy. And hopefully what you're able to do is exhibit your judgment, and to run good hearings, to issue competent awards, and hopeful that there are parties out there who have confidence in you and continue to select you to serve as the trier of fact, as the decision maker, as the arbitrator. So with that, Mr. Canak, thank you very much for inviting me to participate. Thank you to the participants for their patience in getting all the materials, and for whatever flaws and errors are contained in the scenario, they are mine. So with that, I think we stand adjourned for this session. Okay, good. All right. Yes, indeed. Okay, we're done. Good.